Good morning, everyone. I'm Lauren with Bankers Insurance, and welcome to our webinar on how to eliminate confusion regarding the Family Medical Leave Act, presented by Jamie Hasty of SESCO Management Consultants. We've partnered with SESCO for many years, and since 1945, SESCO has provided human resource and employee relations consulting throughout the country. If you're a client of ours, we encourage you to take advantage of your access to SESCO. This webinar will be recorded, and I will share the recording with everyone at the conclusion of the webinar. Please place your questions in the chat or the Q&A feature as you think of them. We will have a Q&A session at the end. And with that, I'll turn it over to Jamie Hasty, the Vice President of SESCO Management Consultants.
Thank you, Lauren. Good morning, everybody, and thanks for joining us to talk all things Family Medical Leave Act. We get a lot of questions from clients nationwide on what do I do with FMLA? Do you have templates? How do I write this? How should I be tracking things? And FMLA can get a little sticky when we're talking about certain eligibilities and integrations with other types of leave or benefits. So hopefully this will be some great information for you. As Lauren mentioned, please feel free to use that chat feature. I will check that towards the end of our time today and answer as many questions as possible. So first things first, not every employer is covered underneath Family Medical Leave Act. There are, obviously states that have enacted their own paid family leave acts that may mirror FMLA, but may have different provisions as well. So for purposes of today's conversation, we are looking merely at Federal Family Medical Leave Act. And that is going to apply to employers that have 50 or more employees. That is total headcount. That has nothing to do with full or part-time status. Okay, 50 or more employees during 20 or more calendar work weeks. And those work weeks need not be consistent, right? So especially if you are within an industry that has a lot of seasonal influx, you may be an FMLA covered employer because within 20 weeks throughout the year, you may have risen above that 50 threshold, even though the bulk of the year you were under 50, okay? We often get questions about, well, is it, 50 equivalents, FTEs? For those that are familiar with the Affordable Care Act, everything that we do on ACA is FTE, full-time equivalents. FMLA deals solely on headcount, okay? We also have to be engaged in commerce. We have to either have 50 or more within a 75-mile radius. So it is not uncommon for us to run across clients who have multiple locations and maybe underneath the 50 threshold at each location, but because they're within a 75-mile radius of one another, they are actually considered a covered employer, okay? And then also who's covered. We have employees on either paid or unpaid leave as long as there is a reasonable expectation that they would return to active employment, okay? So another common misconception that we run into is that, oh, I've been hired in as the employee and I'm automatically covered underneath FMLA. That's not the case. I obviously have to work for a covered employer. But also, in order for me to even possibly be eligible for FMLA, I have to be employed for at least 12 months with that employer. And within that last 12 months, I have to have worked at least 1,250 hours. So the 1,250 hours does not include vacation, personal sick time, holiday layoffs, so on and so forth, okay? 1,250 active hours of work and been employed for at least 12 months. FMLA regulations also address what we call breaks in service. So it's certainly not uncommon where we have employees work for us, they leave, they come back. And I often get a lot of questions on this piece in particular. So with regard to the 12 months of employment, in the regulation, the 12 months need not be consecutive, okay? Meaning, if I have previously worked from an employer, okay, and I was eligible previously because I had been there over a year and I leave and I have a gap of employment for, I don't know, let's say 2 years, and I come back and I've only been back for maybe 60 days, 90 days. Technically, I am covered as an FMLA eligible employee because there is a 7-year look back period. So if we have a break in service that lasted 7 years or more, then my eligibility restarts. Okay. But if I'm within a 7-year look back period and I have eligibility or partial eligibility from the first time I worked, and then now that I'm back, I've been there long enough and those lengths of service add up to be at least 12 months, it's game on. And that's often a rule that a lot of employers do not realize. Okay, so FMLA is unpaid job protected leave, meaning, I am entitled to that leave. I can take that leave for certain reasons. It does not have to be paid under federal law. I can only take that leave for certain reasons. So there are different breakouts of the amount of leave that I may take and for what reason. And so for the purposes of this slide, we're going to look at the first provision, which is up to 12 weeks unpaid for the following reasons. First and foremost, the birth of an employee's child. Okay, that could be mom, that could be dad, that could be a spouse, a legal married spouse, not a domestic partner, in terms of groupings of employment. And I'll talk about that here in just a second. So I can take up to 12 weeks for the birth of a child. Now, questions that I often get with regard to females taking time off for birth is, well, the doctor cleared them at 6 weeks or at 8 weeks. Can't I require them to come back before 12 weeks ends? And the answer is no. Okay, so the birth of the child includes both physical recovery as well as time to bond with the child. Okay, so I can take up to the full 12 weeks, even if I've been medically cleared to return. Okay, and while we're on that topic, bonding with a child also applies to the second bullet point down, which is if I am being needing time off for the placement of a child with the employee for adoption and or foster care, I can take up to 12 weeks to bond with that child. Okay, so then the next one down is when I have an immediate family member. Immediate family member is defined as child, spouse, or parent. Okay. And that child, spouse, or parent must have what we call a serious medical condition. Okay. And I'll talk more about what that means here shortly. Now, the key here for the child, spouse, or parent is that if I am caring for them, I must be designated as the primary caregiver for that person. So often we run into situations that may be questionable under FMLA when we have, let's say, siblings with elderly parents. And the siblings are all taking turns and taking rotations caring for mom or dad. Well, that's not necessarily me being primary caregiver because there are other two caregivers. Some employees are very open and honest about that, and other employees leave that information out. Same concept with, let's say, blended families where mom and dad or mom and mom may be separated and or divorced, and the child needs to go to regular therapy appointments or may have a medical condition. But one parent has to be designated as the primary caregiver in order for it to qualify under FMLA. Now, that doesn't mean as an employer that you can't approve these things, knowing that, look, my 2 siblings were all taking turns, or my ex-husband or ex-wife, we're kind of divvying out the need for this time off on an intermittent basis. But also realize that when we do approve those things outside of that primary caregiver status, that it does set precedents moving forward for anybody else in the future. So the last reason I can take up to 12 weeks unpaid leave is when, as the employee, I am unable to perform the essential functions of my job due to a serious health condition. Okay. Now, that may be on a lump sum basis or an intermittent basis. When we have appointments or follow-ups or those sorts of things, FMLA can be intermittent on the front end or on the back end, from people that have had surgery and then follow-up appointments, those sorts of things. Also within the regulation is what we call military exigency leave. So that allows an individual to take up to 26 weeks unpaid leave to either get the house in order and to spend time, bonding time with an immediate family member being called to active duty, again, child, spouse, parent, and or because I have an immediate family member returning and or recovering from a military related injury. So that's up to 26 weeks unpaid leave. There is also provisions in the regulation that deal with key employees. All right, so a key employee is going to be somebody that is salaried within our organization. They may be FMLA eligible, but they are within the highest paid 10% of all of our staff. Okay. They also still have to work for an employer that's covered within 75 miles. And we determine whether the salaried individual is within the top 10% at the time of the request. The thing about key employees is you technically can deny a key employee FMLA leave. Now, you must be very, very careful about this as well, because A, we need to be able to prove they're within the highest paid 10%. And we also need to be able to prove that if we were to grant this time off for the employee who is a key employee, why that time off would be incredibly detrimental to the organization. Okay. So you can deny the leave and you can deny restoration to key employees only if we are looking at it would be detrimental to the organization. Them being restored back in would prevent substantial and grievous economic injury to our operations. That we have notified the employee of the intent to deny under the key employee provision. And if that leave has already stated. So sometimes situations pop up under FMLA where it was an accident and, I'm in the hospital and I've had to go emergency surgery and those sorts of things. But this is our CEO, our chief financial operations officer. And we, can't have them out for up to 12 weeks. The organization can't function without them. We could, in writing, deny that leave even though they're already out, and notify them that, they may or may not, need to come back. And if they elect not to come back, we may not get in trouble for that piece because they haven't returned within a reasonable period of time. In 18 years of consulting, I have maybe can count on one hand the time that we have enacted a key employee provision. Most employers don't do it. It's important to know that that option is there, but needs to be reviewed very carefully before any sort of denial of request for leave under this provision. Now, remember when I say job protected leave, that is job protection both from a job restoration piece, but also a benefit piece. And I look at those two things separately, okay? So when I go out on FMLA leave, everything stays the same. My benefits stay the same. When I'm ready to come back at the end of that leave, I come back to the exact same everything: equivalent pay, benefits, other terms and conditions of employment. Yes, there are provisions that say original job and/or equivalent job. However, again, you need to be incredibly careful when we're bringing people back and not putting them in the exact same position, the exact same team, the exact same schedule, the exact same location, because there are so many court cases, so many interpretations from the Department of Labor that could nitpick little, what we could view as small adjustments that we could try to argue are equivalent, but I have seen a number of cases go in favor of the employee. And let me give you an example. In a healthcare organization that we worked with many years ago, there was a nurse that worked on the 3rd floor within the building, and it was a night shift nurse. And that night shift nurse was used to that floor, that type of patient that they had on that floor. And that nursing team that worked that shift with them, same charge nurse, so on and so forth. Individual went out, was out for, I believe, 10 weeks, didn't actually fully exhaust the full 12. I was out for 10 weeks. And while that individual was out, the organization temporarily replaced the nurse on that unit, that floor, as it is our right to do. We can temporarily fill the roles of people out on FMLA leave. But when that nurse was ready to come back, that particular organization said, well, the unit is functioning very well with this fill-in, so we're actually going to put you on the 4th floor, same night shift, 4th floor. Okay. And from the employer's perspective, they tried to argue it's equivalent, it's an equivalent job. Well, Department of Labor, upon review of the complaint, determined that the team was different. The type of care being provided on that unit was slightly different from what they were doing, and therefore it was not an equivalent job restoration. So actually the DOL ruled in favor that it had been FMLA retaliation against that employee. So our best recommendation is, yes, you can temporarily refill that position, but when they are ready to return, absolutely do your best to bring them back into the exact same everything. If we're going to try to argue an equivalent job, it needs to be reviewed with a very, very fine-tooth comb to make sure that the terms and conditions of employment are almost, if not identical, to what they were doing previous to their FMLA leave. Another thing with regard to job restoration is the use of FMLA leave cannot be counted against the employee under an attendance policy. Okay. So that's also important to note. And then lastly, with regard to benefits, we are required underneath law to maintain group health insurance coverage for an employee out on leave. Okay. Now, that's not just a free-for-all where they get to stay on the plan and not pay for the plan and all of those things. So where we often find employers get caught up when somebody is out on FMLA is that we either A, haven't notified them of their rights and responsibilities under FMLA to maintain their coverage, or we haven't kept a good pulse on premium payments. It's not uncommon for me on a weekly basis to get a call from a client about, well, I've had somebody out on leave because of baby or surgery or whatever the reason may be. And gosh, Jamie, they owe us $1,000 in back premiums. Okay. So when employees are on FMLA, yes, we have to keep them on the plan, but they are still required to pay their portion of the premium. Okay, that's part of the rights and responsibility notice that they should be provided during their request forms and approval forms. If they are not paying their portion of the premium and they are in arrears, then we need to send a certified letter to that individual, giving them 31 days under the regulation to pay in full before we can even talk about separation of benefits and putting them on COBRA. Okay. And that's often an area where I see employers unaware of that obligation or how to proceed. They're not sure how to proceed. Because most employers pay the premiums, a week prior to the first of the month, and then they recoup those portions through payroll deductions. Now, certainly if we're running paid leave concurrently, it's easy to recoup those, but when the employee doesn't have any more PTO or sick leave or vacation, or the employee is not drawing short-term disability benefits in conjunction with FMLA, we can't take anything from the payroll deduction. So it's important to note that we do have a responsibility to communicate how they're supposed to pay that, what the amount is, and when that's due, and that HR or the office team is really tracking that so that we don't run into situations where we've got a large volume of arrears and we're trying to recoup that. Certainly there are ways where we can kind of recoup that upon return through additional wage deductions, but then that's a separate signed agreement. We have to watch for minimum wage. There's some other wage and hour implications there that can muddy the waters, so to speak. So 5 rules of thumbs from an administrative perspective. We always administratively want to still consider employees that are on FMLA leave as active employees. They are not technically inactive. Yes, they're not, clocking hours. They're not being productive, but they are still an active employee. We have not separated employment. We can't have any sort of adverse action taken against eligible employees that are absent or needing leave for FMLA qualifying reasons because we failed to fulfill our obligations. And we'll talk a little bit more about what that means here shortly, especially when it comes to like the supervisor communications and their training and what they should be looking for. What should be kind of red flags that should initiate the conversation. Another rule of thumb would be that our eligible employees absence or needing leave or returning from FMLA who have not received written notifications cannot suffer adverse consequences because we failed to fulfill our obligations. So a couple of things. You have to have a FMLA policy in your employee handbook. It needs to be written compliantly. You have to have appropriate forms and templates and processes and leave tracking logs. Because if we are not providing the appropriate communications, we can't, say, oh, well, too bad, so sad. You knew that you needed to come back, but we have nothing in writing to support. We followed the law to the T. And if that employee says, well, you didn't notify me of when my FMLA was exhausted, or you didn't follow up, that could put us in a precarious situation with the Department of Labor EEOC. If then we separate employment, the employee can turn around and file a retaliation charge under FMLA. Other pieces from an administrative capacity, employees that are absent or needing leave or returning from FMLA who have received their written required notifications would be subject to the outcome. So let's say we did everything by the book. We gave them the request form, they failed to return it. We followed up multiple times and said, hey, we haven't heard back from you. You've been out. We haven't gotten this certification. And then they just ghost us altogether and just don't respond for a couple of weeks. We could, through our documentation, show, hey, we did everything. We did all of our due diligence. We made multiple outreach efforts. We could separate employment because that is a natural outcome because they were provided with their rights and responsibilities and they failed to follow that as well. Okay. And then again, when employees are returning from leave, it's as if they were never absent to begin with. So if you gave a cost of living adjustment or raises to everybody, but you didn't give it to the people that were out on FMLA, that's going to be a problem. They should have also received that cost of living adjustment. Okay, so let's talk a little bit about the employee responsibilities. Employees do have an obligation to provide us, as the employer, a notice of the need for leave. It's an ask, but there also is responsibility on the employer side that we should be kind of monitoring situations that pique our interest that may qualify and also engage in that. So in most scenarios, employees will tell us, hey, I need to take time off because I'm having a baby or I'm having surgery. But there are many situations where emergencies arise and they can't give us a heads up, or they are out for 3 days consecutive, and then they may need some additional follow-up care, and they may not realize, hey, this could be FMLA. So again, there's dual responsibilities here, but they should be notifying us of the need to take leave if the need is foreseeable. Also, they need to tell us, hey, am I expecting to take this in a lump sum? Or would this be more on an intermittent basis, a day here, a day there, a couple hours here, a couple hours there? And they have to cooperate with us on the medical certification. I'll talk a little bit more about that later during our time, but yes, we have to get things certified. Yes, they have to fill it out. Yes, they need to get it back to us. And failing to do so may impact their approval of that time off. And then they need to comply with any arrangements that you all as the employer are making with them to maintain those health benefits as well. Employees are also responsible for keeping us informed of their intent to return to work. Okay, part of this goes back to the notifications and the follow-up and the touch points that we're going to do. But in our written notifications, there should be explicit instructions that say, hey, you need to notify us if your intent to return is changed or your need for additional time off has changed. Okay, but HR also is going to have a responsibility to keep track of that and to monitor. It's not uncommon for us to hear that so-and-so is out on FMLA, we lost track of time as the employer, and they've been out for an extra 3 or 4 weeks and we haven't heard from them. And the first question I'm going to ask is, well, have you reached out? And they're going to say, well, no, isn't it their responsibility? It is, but it's also our responsibility to keep a pulse on it. Okay. The thing with FMLA, what's really important is, as I mentioned earlier, they have to have an intent to return. So if I tell you, hey, I'm going to go out and have knee surgery, but I've already kind of tendered my resignation, or I've already let you know that in July I'm going to retire or not come back. Well, I'm not going to grant FMLA leave right now for your surgery. Why? Because you have no intention of returning. You're transitioning out of the organization, and the timelines have to kind of back up. It's also not uncommon for people to go out on leave, especially when we're dealing with births, and they change their mind while they're out on leave. Okay. And in those situations, when they notify us, hey, it's been 6 weeks, I've actually thought about it, I don't think I'm going to come back, then we say, thank you for letting us know. We end FMLA and we actually move to separate employment right then and there, because again, they don't have an intent to return. Okay. And then they also have to apply or supply, us with a return to work certification, a fitness for duty, especially if they're taking it for their own serious health condition or for the birth of the child. Before they come back, before they assume the schedule again, we have to make sure that they are fit to return. Sometimes that fitness for duty will show us that they have limitations that we would have to work through and accommodate under FMLA. So there are common mistakes that we often see at SESCO working with clients nationwide that we always find are helpful in kind of covering for employers. And mistake number one is that employers don't have the proper documents. Okay. You have to have an FMLA poster. As part of your federal requirement. If you are over 50 employees, you have to have the FMLA poster displayed with all of the other federal employment posters in a common area that's readily accessible or viewable by employees. If you ever do get a Department of Labor wage and hour audit, one of the first things that they're going to look for is your FMLA poster as well as your FMLA policy in your handbook. Okay. It's like the one thing, and it sounds silly because we're talking about wages and Fair Labor Standards Act, but the Wage and Hour Division does have oversight over the FMLA poster as well as the FMLA policy. Okay. Also, speaking about the policy, you have to have a solid policy in your handbook. That handbook and that policy must be announced, must be covered in your orientation process, or when you are updating your handbook and you redistribute that handbook to be signed and acknowledged, you need to cover that as well. Okay. We also need to have the appropriate request for leave and medical certification forms available. There are forms on the Federal Department of Labor that are fine. SESCO has forms. So you have to have the appropriate medical certification forms and requests for leave. Okay. Then you also have to have required written notices available for employees who do request leave, or notices for when we are initiating that process, because we think it may be FMLA qualifying based on kind of our initial facts and circumstances. Typically, those letters are voluminous, and we want to make sure that the employers are set up for success there. So mistake number 2, as I mentioned earlier, yes, the employees should provide a request if the leave is foreseeable. However, they are not required to directly ask for FMLA leave. That is up for the employer to review and designate and engage in the process. And I can't tell you how many times I've gotten calls where, well, somebody's out on workers' comp, somebody's out on short-term disability, and I know that it's a large employer. My first ask is going to be, how long have they been employed and did you designate FMLA? And a lot of times those clients will say, well, I didn't think I had to because it's workers' comp. Those leaves can run concurrently, as they should, because what we don't want to do is have somebody make the allegation that their FMLA rights were denied. Okay, so depending on the need and the reason why we need leave, the notice period is going to vary. In a perfect world, the employees have to give us 30 days notice that we need leave, heads up. This helps us anticipate timing, the duration, helps us have a little cushion on getting the appropriate paperwork put together, sent off, received back, and processed. Now, in situations where leave is unforeseeable, I had an accident and I'm in the hospital. My appendix ruptured. Certain things where, oh my gosh, my family member, my immediate family member, had a serious health condition. They took a turn for the worse, and I need to be there and care for them. Those things are not typically foreseeable, right? Life happens. So the employee only needs to give us enough information for us as the employer to say, okay, this could be FMLA, and let's work to get you the paperwork. Mistake number 3 is dealing with the supervisor. So when we look at Department of Labor EEOC charges, oftentimes there are allegations that are ruled in favor for the employee where the supervisor and their lack of knowledge about FMLA was a part of the reason for the alleged discrimination of rights. Okay, so the important piece with the supervisors is that we as the employer are providing training on FMLA to the supervisor. I don't expect the supervisors to be experts in HR, okay? But they need to have a fundamental understanding of what FMLA is. How does it work? What should be red flags that I should be looking at? Who do I refer them to when a potential situation arises that I think, hey, this may be FMLA, actually go talk to HR or go talk to the office manager. And they need to understand what questions to ask when an employee calls in sick. Okay, so for short absences, typically within 3 days. Have you seen a doctor? When do you expect to come back? And are you under the ongoing care? I don't want to know exactly why, what your diagnosis is. I just want to know, are you going to go see a doctor? When do you think you may come back? And how long do you think you're going to be out? If it's longer than 3 days, that's a red flag to the supervisor that whoever is handling the FMLA process should be notified, hey, you need to reach out to this employee. Okay. For short or extended absences, we don't want the supervisors to ask, well, why are you out? What are you having surgery for? What's going on? That can open us up to having confidential medical information knowledge or reveal a disability or a diagnosis that we don't want the supervisors to have knowledge of. Remember, it's important that these things are confidential. Sure, a manager is going to know if somebody's out on FMLA leave, but they don't need to always know the intricate details of the medical condition leading up to that leave. Mistake number 4 is individuals often don't understand what is considered a serious health condition. A lot of employers still think, oh, well, you know, I take FMLA only for surgeries or for births, and that's not the case. A serious health condition is going to be any sort of illness or injury or a physical or a mental impairment or condition that can involve one of these two things. Either A, inpatient care, which is overnight in the hospital. If I go to the ER because I'm having pain in my side and they're running diagnostic tests and they keep me overnight and they say, okay, well, we can't find anything, we're going to release you, but follow up with your PCP or the specialist to get checked out further. That 24 hours within the hospital technically triggers FMLA. Okay. Also, as a serious health condition is continuing treatment by a healthcare provider, which is twice in a 30-day period. So if I go to my neurologist and I'm like, oh gosh, I have these migraines, I can't figure it out. I see them once, and then I see them again within 30 days for follow-up tests, and they give me a diagnosis that maybe I have a brain aneurysm that doesn't require to be operated on right now, but every 6 months they want me to come back for scans and checks. Technically, I am now covered underneath FMLA for that initial visit, the diagnosis, subsequent visit, and then my 6-month follow-ups. Why? Because I saw them twice in a 30-day period for ongoing care. Okay. If I'm given a course of prescription medication, if they are referring me to therapy, addiction treatments, those sorts of things, those treatments would apply for purposes of FMLA. But normal routine things, my dental exams, my eye exams, my physicals, routine visits and checks are not going to qualify underneath FMLA. Now, let's talk about documentation, because this is really, really critical to the FMLA process. I mentioned that we have to have appropriate written notifications and forms and templates, and it is a lot. It is a lot. So you definitely need to have templated letter as well as medical examiner certification templates at your fingertips. Hey, based on the information you have provided us, we feel like this may qualify for FMLA. Please take this medical certification to your provider, have them complete it, and return it to us. They have 15 days. And it's important to note, it is 15 calendar days, not business days, to return that medical certification. Now, there is a loophole in the regulation that talks about the 15-day grace period. Yes, technically, I can hold their feet to the fire on the 15 days. However, we all know that oftentimes in dealing with medical providers, sometimes they are slow to get that information back to us. So as long as the employee is demonstrating a cooperative attitude and they are keeping communication open with us and regarding, hey, I've sent it to them, I've asked them to complete this, they said they would get it back to us, Hey, I know my paperwork's due tomorrow. I still haven't gotten it back from the doctor. I'm going to call them today. As long as there's open communication, DOL says there is cushion on that 15-day period. Okay. So as long as they're cooperating, that 15-day may end up being 20 days, 25 days. Now, it's probably not going to be a 3-month look back, but there is some cushion there as well. Okay. Once we get that medical certification, it needs to be reviewed. It needs to be looked at. Was it filled out completely? Are there areas that we need clarification on? Is it very vague? Did the provider complete it correctly? If they didn't, we can send it back and say, hey, you checked this box that said they're incapacitated, but then in this area, you said that they're able to return to work. This is confusing. Can you give us information? Also with medical examiner certification, it's not uncommon for us to get second and or third opinions if necessary. And typically I only run into that situation when the medical certification says one thing and the employee is telling me something completely different. Okay. And then that leads me to be concerned that we have different information flowing. So let's go get a second opinion. It's also not uncommon for us to get second or third opinions when we already have somebody on leave and maybe we suspect that there is abuse of FMLA. Maybe they're consistently taking off Fridays and Mondays. Or maybe their initial medical certification said they would only have 1 to 2 flare-ups a month, and they could last, up from a half day to a full day. And I'm looking at the attendance records for this current employee, and they're calling out 2 and 3 times a week for this. That should be a red flag to HR. That we would need to get an updated medical certification, and or if that still reiterates the 1 to 2 times a month, then we get a second opinion. But just know that if we are going to ask for second and third opinions, especially if you're going to require them to go see a specialist, that those visits are at the cost of the employer, not the employee. We would need to pay for that second and third opinion. Okay. Once we get medical examiner certification back, we review it, we determine whether this is or this isn't FMLA. Then you have to send a designation letter. Hey, we're approving your leave. It begins on this date. It would end on this date. Here are the terms and conditions of your leave. It's intermittent. It's in lump sum. If it's a lump sum, they can't be performing any work whatsoever while they are on FMLA leave. Remember, FMLA is designating that they are incapacitated. Okay. If we are doing half days or reduction in days for leave, fine, that's a different story. But your designation letter should really outline when does it start, when does it end, what are their expectations. Here's a reminder, you still owe us for your portion of the premium. You have to keep us informed of your intent to return to work. And you're going to be required to provide a fitness for duty clearance prior to return. Then once we send that out, we should be kind of just keeping tabs through your FMLA tracker on dates, right? And prior to the exhaustion of leave, there's another letter that needs to go. Hey, Jamie, heads up, your FMLA approved leave is going to end July 15th. That letter needs to go a week or 2 before the July 15th deadline. Why? Because I need to provide them with a medical examiner certification, a fitness for duty to return to work. Hey, here's your form. Remember, you have to get this completed and returned to us before the 15th. If you need additional time off, use that form because the doctor needs to certify that you need additional time off. So there has to be an exhaustion of leave letter also sent. And it's important that all of these notifications are sent hard copy in a form that we can track it, whether that's certified USPS, whether that's FedEx, UPS, whatever. I want to be able to show that the letters were delivered. Now, it's perfectly acceptable that you send electronic communications to personal email addresses, not work email addresses, personal email addresses with a red receipt. But if you're going to do that, I still want you to send the hard copy. Why? Because remember, we have to defend our due diligence that we engaged and followed the FMLA process correctly. Also with the documentation, it's not uncommon for us to get questions about, hey, this licensed clinical social worker filled this out. Are they allowed to do that? This physician assistant filled it out. This RN filled it out. It's not just doctors that can complete that certification. So FMLA really has a definition of healthcare provider, and it defers back to how the Secretary of Labor has defined a healthcare provider as anybody capable of providing services. So podiatrists, dentists, psychologists, optometrists, chiropractors, NPs, LCSWs, physician assistants, those people can absolutely fill out that form, okay? Mistake number 6, we see this so much, is that employers fail to integrate FMLA with other leaves. I mean, here's the reality, folks. You can be on FMLA, ADA, workers' comp, short-term disability, paid time off, all at the same time, okay? So again, it goes back to, is this person going to be out for 3 days or longer because of a serious health condition? Even if it's workers' comp, that still is FMLA. You run those things concurrently. It's also really, really important to have good time tracking pieces in place. Every organization is different. Some have FMLA tracking systems integrated into their HRIS systems or an employee navigator, or they're manually tracking it on an Excel spreadsheet. Do what works for your organization so long as we're tracking time. This is especially important with intermittent FMLA, right? Because remember, it's 12 weeks. Okay, so if I'm taking 2 hours here, 2 hours there, a half day here, 4 days here, we need to have all of that tracked for time and attendance under FMLA, but also in our payroll system. So I know what PTO and other things that I'm running concurrently. It would be most advisable for you to run any paid leave also concurrent with FMLA to avoid the employee exhausting all of their vacation or PTO first and then kicking in FMLA, because then they're out a lot longer than what they really are entitled to. Mistake number 7 often is that the employee and the employer are not communicating appropriately. Neither party or one party is not staying in touch as it pertains to return to work. The employee is not giving us updates on health and fitness. Managers are not notifying HR, or the employee is not managing or notifying their manager of intermittent days and time off. So nobody really knows what days are for what. And that we are, often not keeping them informed of their past due arrears as it pertains to that benefit portion that they're still responsible for. Mistake number 8, and this is something that has changed over the last 8 years or so. It used to be that when somebody had exhausted their FMLA, and when I say FMLA for purposes of serious health condition, and then they are unable to return to work because of their serious health condition, we used to be able to terminate. Yeah, sorry, your 12 weeks are up. Sorry, you can't come back. We wish you the best, but today's, we're going to separate employment. Department of Labor no longer allows that, because most serious health conditions, especially when I've taken up to 12 weeks, and I'm unable to return, and let's say that medical note, that return to work fitness for duty says, you know what, Jamie actually needs an additional 4 weeks off because she's having complications with recovery. That medical condition is likely covered underneath Americans with Disabilities Act as amended, meaning that as the employer, I now have to explore a reasonable accommodation on the back end of FMLA in the form of a personal leave of absence. Okay, so you can't just immediately terminate FMLA. Now, if the person has no medical reason for needing to remain out, that's a different conversation. Okay, but if medically they are unable to return and they need additional time off, general rule of thumb is that personal leave of absence should be no less than 30 days additional under ADA, but typically it should be at or around 60 days. Okay. The courts are now requiring us to apply ADA following FMLA leave. So those are common mistakes that I often see with employers nationwide, looking at all of that. I do want to hopefully address some Q&A, Lauren. It looks like there's some things in there that we can look at, but also if you have questions, please feel free to utilize that chat feature, and I'd be more than happy to address those for us. So question that came in the Q&A, do partners and owners count in the head count towards the 50? That's a great question. Yes, they do. Owners do count towards the 50. Okay. And then also additional questions that came in. What if an employee does not furnish or return the certification to return to work? So that's a great question. Again, we just want to have good, clear documentation that we've issued the return to work, we've requested it, we've given deadlines when that documentation needs to come back. We are documenting when we called, how often, no response, we left a voicemail, we followed up an email, it's been 10 days, here's your final notice, hey, we need this to return. So you want to do your due diligence and do multiple outreaches prior to saying, you're unresponsive, we're going to assume that it's a voluntary resignation. Another good question that has come in, must PTO accrue while someone is out on FMLA leave? Technically, no, it does not have to, because remember, typically most employers have their PTO accrual tied into hours of work, right? So I've seen policies written both ways. I've seen policies written where an employer will allow the PTO to maintain accrual. And I've had policies written where no, PTO does not accrue while you're out on FMLA leave, lump sum leave. You know, intermittent's a little bit different because they may be taking hours or halftime, what have you. So it really boils down to the culture and the approach that you want to take within your respective organization. Question also, what does the process of placing an employee on ADA following expiration of FMLA look like? Great question. So remember when we send the FMLA exhaustion, you got to have the return to work clearance, and we send that fitness for duty exam. We get that back, we look at what that fitness for duty says. Again, the doctor may say, look, they need 4 weeks, 6 weeks, 8 weeks, 12 weeks, whatever it may be. And then we look at, knowing the court standard is at or around no less than 30, but typically 60, we are going to then say, okay, we're going to send a follow-up letter that says your FMLA has exhausted. We understand per your fitness for duty information that was submitted to us that you do require additional leave off from work. Upon review, we are able to grant a personal leave of absence in the form of a reasonable accommodation for 30 days, 60 days. And so your new anticipated return to work date is going to be blank. Prior to then that date upcoming, you're going to then follow up again. Hey, we're touching base. We gave you an additional personal leave of absence under ADA. We need an updated medical certification to see, are you able to return and in what capacity? Because remember, ADA is also, just like FMLA, going to require us to maybe make additional accommodations when they return for light duty, for flexibility. There's a lot of things that play into that piece, but it's solid documentation review, send follow-up notification in writing, and monitoring those timelines and what the return to work process looks like as well. So that's a great question there. Another question that has come in: during a personal leave of absence after exhausting FMLA, is the employer required to bring the employee back in the same capacity and position? Ooh, that's a fabulous question. So in my FMLA exhaust / ADA letter, I always put the disclaimer that the employer will do their best to bring them back into their same position. However, we are not obligated to do so under the ADA reasonable accommodation process subsequent FMLA. So certainly we do our best. I think there's a lot of factors that play into that. You know, look, if they're out for another 15 to 30 days, chances are we can make it, although not ideal, we can make it with that position still being, you know, available to them. I have seen subsequent ADA leave of absences for 6 months, 9 months after FMLA, and it's just not feasible for us to bring them back into that role unless we've had turnover while they were out. Question on if I can provide templates for these letters. If you are a retainer client of SESCO, yes, I can provide those templates under the retainer agreement for your organization. But otherwise, they are available for electronic download and purchase that way for a very reasonable fee. You can reach out to SESCO to discuss what those fees look like, but it's very nominal. Question that also has come in: what is our recommendation if the team member is unable to complete the FMLA paperwork due to be very sick? Can the FMLA paperwork be provided to their assigned emergency contact? Absolutely. We run into that all the time. Obviously, make sure that it is somebody that is their actual emergency contact, that is documented somewhere. It's not uncommon when we have spouses or family members say, hey, Jamie's in a coma. She can't respond. What do I do? And we work through the family member there. So yes, you can do that. Make sure it is their designated emergency contact as well. But remember, it's only for communicating the paperwork and getting the paperwork returned. The approval and that sort of thing still has to be addressed and communicated to the employee. You can let them know, hey, I'm forwarding this approval, but remember, terms and conditions of employment can't really be divulged to emergency contacts. It has to go to the actual employee. So that's a fabulous question there. Any other questions that I might be able to answer for you all? Let's see.
We have some in the Q&A feature, Jamie.
Got it. Perfect. Let me look there too. Is there something after ADA if they have to stay out longer? Yeah, that's a great question. So ADA is kind of wide open in some respects. Typically, I would say if they're going out on ADA 30, 60, 90 days, then we need to have an internal conversation of how much longer can we really accommodate this leave? Is it feasible? If it's not, then, and it depends on what's going on with them. Sometimes really their medical conditions have risen to the level where they need to do, you know, permanent disability because they're just not able to return. The doctor's saying, oh, they need another 6 months off, or we're not even sure if they can return. ADA, I mean, I've had people out on ADA for a year, year and a half. So it really just is about what we can accommodate and what we can't. But I always recommend that if those situations arise, that you do speak with an employment law expert on kind of pros and cons and areas of choice and what those options look like, and also areas of liability there. Oh, good question. If you have less than 50 employees, should you still follow FMLA even though you don't have 50 employees? No, I wouldn't. Certainly it's your right as an employer to do that, but know that if you follow FMLA, then an employee can allege that you have engaged and are going to be bound by all of the FMLA regulations. So you could open yourself up to unintended liability as a small employer under 50 employees within a 75-mile radius. If we didn't follow something appropriately, the employee could go to the EEOC and say, well, they have a policy. It looks just like FMLA. I assumed they were. And not to say that you wouldn't win that argument. The DOL may rule in your favor. Hey, technically you didn't have to, but it's still time and money to defend an EEOC charge that may sit out there for 6 to 18 months. So I would recommend if you're under 50, really think long and hard about whether you want to follow FMLA, even though we're not required to do so. All right, I think it looks like I need to go back to the chat. There may be more. I think that's it, Lauren. I don't see any other questions. All wonderful questions.
Mm-hmm. Yeah, I think that's all the questions. Thank you, Jamie, so much. And thank you, everyone, for joining us. We really appreciate it. I will be sending out the recording after the conclusion of our webinar, and have a wonderful day.
Thank you, everybody. You too.